All right, welcome back to class. This is American Federal Government. My name is Ken Hicks. We spent a couple of classes talking about federalism, which is a very important and a very kind of complicated issue that creates a real kind of decentralized, fragmented approach to governance. And American federalism tends to be a little bit more decentralized even than most other systems of countries that use federal systems of government. Today we're going to move on, and we're going to start talking about civil liberties. I wanted to take a moment to talk a little bit about another current event that occurred. I believe it was yesterday or the day before. Donald Trump was at one of his golf courses in southern Florida, and apparently Secret Service identified another attempted guy that wanted to assassinate Donald Trump. This guy had a number of run-ins with the law, and he apparently Secret Service spotted a rifle barrel of a high-velocity rifle or some kind of rifle sticking out from the foliage of the golf course, a couple of rounds ahead of where Donald Trump was actually located at the time. Trump did not appear at any point to be in any danger, but at the same time, it reflects just how kind of dangerous the political environment has gotten, where there are people out there that appear to be motivated to try and kill someone, and that's a dangerous place. That is a genie that's very hard to put back in the bottle. We have had kind of these bursts of assassinations. They tend to occur in, like I said, bursts. They tend to, you have several, back to back to back. When you think about it, 1968, you had both Martin Luther King and Robert Kennedy assassinated within a span of a couple of weeks, and so again, this is dangerous. No one should think this is fun, or that anybody should express any kind of regret, whether you support Donald Trump or not. Assassination is not a way. It's not a healthy way to work out your political feelings. Once again, I think that Trump has been fortunate in that the person that was attempting to kill him was not a trained sniper, because someone with training would not have had their rifle barrel sticking out beyond the foliage. It's once again, a very dangerous situation, and it kind of feeds into what we're talking about today. We are talking about civil liberties and the idea that as citizens, government is constrained from putting certain kinds of impositions on us because as citizens and frankly as human beings, we are bearers of rights, and within our legal system, that means that government has to follow due process if there are any kinds of ways that they want to control our behavior. So what exactly are we learning today? I'm going to talk a little bit about the origins of the Bill of Rights, and again, it emerged out of the ratification debates. We're going to talk a little bit about the First Amendment and the guarantees of religious freedom that emanate from the First Amendment, and then we'll talk about the First Amendment's freedom of speech and of the press, and the importance of freedom of expression in ensuring the free exchange of ideas. Okay, so the Bill of Rights originated with the opponents of the Constitution. Okay, at the end of the Constitutional Convention, there were these ratifying conventions that were held in the 13 states, and in many of those states, the people who opposed ratification of the Constitution said that their main complaint was the absence of a federal Bill of Rights. Now, many of the states had their own bills of rights. At the Constitutional Convention, they considered a Bill of Rights, and I'll talk a little bit more about that in a moment. Ultimately, they decided that a Bill of Rights was not necessary for a couple of reasons. So one thing we want to talk about is the distinction between civil liberties and civil rights. So civil liberties are, again, a hallmark of any kind of liberal political order. Now, I just used the word liberal. It means something more complex than what many viewers might think it means. Liberalism in its original sense simply meant kind of liberal-minded, but as it evolved as a philosophical movement in the 16th and 17th centuries, it came to mean a philosophical belief that individuals matter, kind of methodological individualism, the sense in which individuals matter and they matter individually. We are bearers of rights, not because we are members of some political community, but in our own right. We have our own, our own right to equal dignity and equal recognition. So civil liberties reflect this idea that government intervention has to be clearly justified, and there has to be some clearly articulated reason prior to to a government intervening and regulating a person's rights. Civil rights, on the other hand, reflect the idea that while we have been predominantly a liberal society, we haven't always been liberal. We have often been governed by rather illiberal tendencies. And civil rights reflects the idea that governments have periodically failed to respect the civil liberties of what, in the legal term we call disfavored groups. Women, for much of American history and much of human history, were treated as less than meriting equal recognition compared to men. Members of certain groups, Jews, blacks, Hispanic Americans, Asian Americans, Native Americans, members of the LGBTQ plus community, all have been at various times subject to differential treatment by virtue of those aspects of their identities. And as a result, that leads to claims to civil rights to redress that discrimination. So why did we need a Bill of Rights? Again, as I mentioned, at the Constitutional Convention, they considered the idea of adding a Bill of Rights, in part because a lot of states did have their own bills of rights. It was ultimately rejected by a vote of the ratifying, by the Constitutional Convention delegates, on the grounds that really the federal government would not be interacting with individual citizens that much, that they would be simply managing the relations among the states and between the United States and foreign governments. And so the perception was there'd be very little need for an actual Bill of Rights. So the Anti-Federalists played a very important role during the ratification debates in raising those concerns. And so, in fact, you ended up in the election. Once the Constitution was ratified, there were certain elections that were held that were closely fought. And you ultimately had, for example, James Madison running against a fellow, a person who would later become a president in his own right, James Monroe, who was a younger man at the time. And they ran in the same, district in the House of Representatives. And Madison basically made the promise that he would lend his hand to drafting a Bill of Rights if he were elected. And ultimately he narrowly won, was sent to Congress, and served on that committee that drafted ultimately there were I can't remember the exact number, but there were far more than 10 amendments that were initially considered, but it was winnowed down within the committee, and some things were incorporated into one amendment. So ultimately you ended up with 10 amendments. So the First Amendment process that emerged in the opening years of the Republic under the Constitution resulted in ratification of what we now call the Bill of Rights. When you look at the Bill of Rights, you can see that there is an architecture to them and that they reflect four separate broad areas of concern. The first one, of course, is the First Amendment. And the First Amendment is, I think, vital to understanding the constitutional protections the civil liberties protections that are provided by our Constitution. And it basically bars Congress from making a law establishing a religion, and I'll talk more about that in a minute, or abridging freedoms of religious exercise, speech, the press, assembly, or petition. All of these things, and again, the First Amendment is enormously consequential because it protects the idea of freedom of expression. People have maximum liberty to express their political ideas, even if their political ideas are unpopular. The second constellation of rights, and actually they're related to the fourth as well, the Second, Third, and Fourth Amendments basically say that the federal government cannot infringe upon the right of the people to keep and bear arms, and cannot arbitrarily take houses, private homes for militia use, and cannot search for or seize evidence without a warrant swearing to the probable existence of a crime. These are a kind of mix of things, but again, they are ensuring, on the one hand, that the federal government cannot infringe upon the privacy of individuals. And I would also make the argument, and I made this argument with the federalism presentations as well. The Second Amendment is primarily understood as preserving the right of the states to raise and train militias. Okay? The third constellation of rights, the Fifth, Sixth, Seventh, and Eighth Amendments, relate to people accused of crimes. Now, why were they worried about that? Those amendments reflect this idea that the framers did not want to see the government and the government's enforcement of the law used as a political cudgel to attack opponents of those people who were currently in political office. And that, they understood this from the days of the Roman Republic. They understood this from ancient Greek times, and they understood it from the practice of politics oftentimes in England, where people who rose in prominence and who were rivals to people in power oftentimes found themselves suddenly in legal jeopardy, not because of anything that they had actually done, but because of their status as political rivals. So with that sense, you cannot hold a trial, you cannot indict a person for serious offenses without a grand jury basically handing down that indictment. And again, that is a jury of the people's, of an accused person's peers. People have a right to a jury trial. People have a right to a speedy trial. They have a right to have charges and witnesses to be brought forth. They have immunity from testimony against themselves and immunity from trial more than once for the same offense. And that idea of double jeopardy is very important because there have been instances where the state simply keeps accusing the person of the same offense. That is, again, a method of harassment, a method of wearing a person down, of eroding their personal resources and destroying them politically. And then finally, you can't inflict excessive bail, impose excessive fines, nor can you inflict cruel and unusual punishment upon a person who has been convicted of a crime. And that, again, is a reflection of this idea of avoiding revenge types of punishments. The last constellation of amendments, the Ninth and the 10th Amendments, the Ninth Amendment is interesting in that it basically says just because we haven't listed all these rights doesn't mean that other rights don't exist. Okay? And then the 10th Amendment basically is the reserved powers clause, which we talked about in the presentations on federalism, and it reflects this idea that the enumeration of certain rights in the Constitution should not be interpreted to mean that those are the only rights that people have, and that those powers are reserved to the people or to the states. And so you can see that there is this architecture to the Bill of Rights, and that they are interrelated. And again, the intent behind them is to preserve people's right to exist free of government interference, unless the government can clearly demonstrate that that a person is a threat to the community. Now, in an important sense, we need to keep in mind that initially the Bill of Rights only applied to the federal government. Okay. In fact, in an early 19th century case in Barron versus Baltimore, the Supreme Court basically ruled that the federal Bill of Rights only applies to the federal government, does not apply to the states. So ultimately, as a result of the Civil War, you ended up with a fundamental revision of our Constitution through the three Civil War amendments, the 13th, 14th, and 15th Amendments. The 13th Amendment, again, bans chattel slavery, which actually has implications for today because you cannot force, for example, someone who has been convicted of a crime and imprisoned. You can't force them to do labor that they're not compensated for, at least minimally. And so that is part of, that is one of the implications of the 13th Amendment. The 14th Amendment is one of the most dramatic revisions of our Constitution. I think I've mentioned this before, but sometimes repetition is good. And that is telling you that again, the people of the citizens of the states are also citizens of the United States, and they are protected by the Constitution. And Congress has the power to regulate the behavior of the states to ensure that they are providing equal protection under the laws, and that all citizens are provided due process. So again, if you read that critical, and again, there's more to it, the 14th Amendment, than that, and we'll talk more about that in later presentations on civil rights. It basically reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within the jurisdiction the equal protection of the laws. That is again an enormously sweeping constitutional amendment that creates the legal interpretation, the legal doctrine of incorporation. And again, that reflects the idea that the Bill of Rights is then incorporated into the states, and the states are now governed by the same Bill of Rights that the federal government is. Now, initially, the Supreme Court interpreted incorporation in a highly selective manner. They basically said that we will judge these cases on a case-by-case basis as to whether this particular right is incorporated and applied to states to limit their behavior. So when you look at this slide, it shows you that the Fifth Amendment's protection of eminent domain was first incorporated in 1897. That is the first time that a right was incorporated, and the states were thereby informed that they had to respect eminent domain, which again is this idea that yes, private property can be seized by the government for public uses, but they have to provide, there has to be a public use for it, and it has to be justly compensated. Keep in mind, take a look at this slide, the freedom of speech is not incorporated until 1925 in the case of Gitlow v. New York. And that was a situation where you had Benjamin Gitlow, who was a socialist, who had been distributing pamphlets basically decrying U.S. entrance into World War I and calling for kind of a revolution. The court basically upheld his conviction under a New York sedition law. But they also said Gitlow does have, free speech rights. Freedom of the press was incorporated in the case of Neer versus Minnesota in 1931. Importantly, when you think, for example, about double jeopardy, initially in the 1930s, that was effectively not incorporated. And basically they said, we're not going to worry about that. The person that the case dealt with, Palco, this was Palco v. Connecticut, he had killed a cop while he was committing a crime. The state tried him, but the jury basically handed down a life sentence rather than executing him. Connecticut retried him, and with a different jury, got a death sentence. Palco's lawyers appealed, basically saying his double jeopardy rights were violated. In the 1930s, the court basically said, you know what, that's okay. We don't believe that double jeopardy is so essential to ordered liberty that we need to invoke this and strike down this conviction. And so it was not until, I believe, the late 20th century that double jeopardy was actually incorporated. So the First Amendment guarantees freedom of religion. And again, that was an important thing. Many of the colonies were actually established by religious dissidents who were invited to leave England because they were kind of viewed as troublemakers. And so these folks placed a premium on the right of the people to worship how they chose. The first idea is this idea of the Establishment Clause, okay? The First Amendment basically says that the federal government will not establish a religion. In other words, they would not declare that the United States was a Baptist country or a Catholic country or an Episcopalian country. And part of that is reflected in the realities of the colonies. They were, in many instances, dominated by one particular religious grouping. Each of the states were dominated. Massachusetts was predominantly a Puritan state, and then ultimately it became more and more of a Catholic state later on in its history. Pennsylvania had a lot of Quakers in it. Virginia had a lot of Episcopalians in it, and so the reality, Maryland was established as a Catholic colony, and so the realities of that religious pluralism meant that trying to establish a national religion was a recipe for conflict. And so it's important to keep in mind that in Europe, that's really how the nation state evolved. It evolved around the conflicts over religion. Where, again, France was a Catholic-dominated state. Spain was a Catholic state. England was an Episcopalian state. And so, the wars of the Protestant Reformation, the 100 Years' War, really reflected this idea that religion could be a unifying bond. In the early years of the United States, that simply wasn't going to work, okay? So there are three possible interpretations of the Establishment Clause. The first interpretation is the idea that the federal government is basically barred from establishing an official church, and that has largely been the dominant interpretation. The second interpretation suggests that government may assist without taking sides in religion. So they don't necessarily have to be, strictly speaking, neutral. They can undertake policies that promote religion generally, so long as they are not seen placing their thumb on the scale of one particular religion. The third one is this idea of the wall of separation, the idea that there is this barrier between the church and the state that prevent an intermingling of religious belief with, public affairs. And that one has, that view prevailed for a long time. But over time, in fact, that viewpoint has sort of eroded, okay? That in fact, many people want to make the argument that the United States is a Christian, nation. That is really contrary to what the framers believed and wanted. But nevertheless, there is a significant, segment of the American public that believes that. For comparative politics scholars, we tend to refer to the United States as sort of a denominationalist society. Whereas with France, where France would basically say, we will not allow religion in the public square. We will not allow Muslims to wear Muslim women to wear burqas. We will not allow Jewish Americans to wear yarmulkes. That is a policy that the French call laïcité, which is, again, this idea that we will keep religion out of public deliberations altogether. In the United States, we oftentimes do allow for religious expressions, and very frequently, arguments are made in straightforwardly religious terms. If you think about the Supreme Court's decision in Dobbs versus Jackson Women's Reproductive Health Services, Samuel Alito's decision, in my view, is religious. It is a moral argument. He is basically making an argument from a Catholic perspective, but he is also making an argument claiming that there is no right for women to terminate an unwanted pregnancy within the Constitution, completely ignoring the Ninth Amendment, again assuming that there are rights not in existence that do not need to be enumerated. And we are having that argument today. Some states are strictly banning any kind of access to abortion and actually trying to prevent women from traveling to states where abortion is legal. And other states are allowing it. And the question is going to be, and we talked about this during our federalism, presentation, where again, both sides want to nationalize this. Both sides want to impose their preferred solution. For reasons that they believe are good and moral. For example, if you are opposed to abortion, you believe it's, probably most, opponents of abortion believe it's a kind of infanticide. On those grounds, you're basically making a moral argument. Most people who support women's reproductive rights do not believe that an unborn fetus has rights that bar a woman from stopping a pregnancy. And on those grounds, I believe they are also making a moral claim that denying women access to reproductive health care ultimately ends up eroding women's health care overall, and basically eroding their citizenship as well with it. So the area where you see this wall of separation, the erosion of the wall of separation most, is in the idea of public education. Now, in the United States, public education, it became sort of a national thing in the late 19th, early 20th century, when we were getting large waves of non-English speaking immigrants. And basically we didn't have strict immigration laws until very late in the 19th century, and it was primarily targeted at Asian Americans. And so when you're getting Italians and Polish and Turkish, folks coming in to the country at this point in time, and Greeks coming into the country, they don't speak English. And so the idea was to, get their children into public schools where you could teach them English and where you could teach them basic skills that they would need to join the workforce. And so that was the original intent behind public education. Now, not surprisingly, the idea of teaching people the skills about what it means to be an American naturally raises the issue of, should we be teaching them religion as well? So in 1971, the Supreme Court handed down a decision. This was an 8-0 decision. I think one person was either involved in the case and recused themselves, or there was a justice that hadn't been approved, hadn't been confirmed yet. In that case, in Lemon versus Kurtzman, the court established a three-pronged test for avoiding undue religious entanglement of publicly funded and operated enterprises like public schools with religion. The first prong of that test is that a statute or practice must have a secular purpose, that it was not necessarily designed to promote a particular religion, especially. Secondly, the principal or primary effect of the statute must neither advance nor inhibit religion. And three, the statute must not result in an excessive government entanglement with religion. The Supreme Court, up until fairly recently, consistently struck down instances where government agencies or public schools were mandating organized religious activity. In 2022, however, Kennedy versus Bremerton School District, the Supreme Court upheld a coach's prayer at the 50-yard line as a free exercise issue. And I'll talk more about that in a few minutes. The free exercise clause is the second aspect of the First Amendment's protection of religion. And that, again, reflects this idea that, like with freedom of conscience, you have the right to express what your religious beliefs. Now, the court has consistently protected reasonable exercise of religious beliefs and practices. And again, what that typically means is that a religious belief is acceptable so long as it is essentially a private matter relating to their personal beliefs. So in West Virginia State Board of Education versus Barnett in 1943, the Supreme Court basically protected the right of Jehovah's Witnesses to not salute the flag or engage in the Pledge of Allegiance, because people who are Jehovah's Witnesses believe that that is kind of worshiping false idols. In 2014, in Burwell versus Hobby Lobby, the court struck down a section of the Affordable Care Act that mandated large employers that they provide female employees with contraceptive coverage. And again, the owners of Hobby Lobbies are deeply religious. If you've been to a Hobby Lobby store, you'll find that there are books on sale and that virtually all the books are religious in nature. That reflects the beliefs of the people who own, the family who owns Hobby Lobby, and they happen to not believe in contraception, and they don't believe that they should be compelled to provide contraception to their employees. And so as a result of that, the court basically held that it was reasonable for them as employers to not have to include in the insurance plans that they provide to their employees contraceptive coverage. And so as a result, people that work in stores like Hobby Lobbies or fast food places like Chick-fil-A, the employers don't have to provide contraceptive coverage if they don't agree with the idea of contraception. Free exercise of religion had, again, a number of challenges during the COVID-19 pandemic. A number of the initial outbreaks in the United States occurred in churches where, again, people were engaging in the kinds of activities that tended to spread COVID-19. COVID-19 was transmitted by, aerosolized droplets of air. When you exhale, a certain amount of water goes out with it. It's aerosolized, which means it's in microscopic droplets, and those droplets tend not to simply fall to the earth. Oftentimes they will float, they will rise, and so they can spread. And the result was, again, in many instances, several states and a number of municipal governments imposed bans on in-person worship. And churches challenged those bans. Now, some churches accommodated, those situations. They basically said, "Is it okay if we hold a church service in the parking lot where people simply sit in their cars or sit on their cars or sit in the beds of their trucks and pray in the parking lot?" Most local governments viewed that as a reasonable accommodation. However, a number of churches challenged the bans, and the court ruled in a 5-4 decision that prohibitions on in-person services violated the free exercise clause. And again, this was a situation where you're creating a legal environment where public health is going to be further undermined because people insist on going to church, and they insist on singing and doing, again, the things that create a highly transmitting atmosphere. And vulnerable members of those congregations were exposed to COVID-19. And I don't think there's any question that many of those vulnerable members, many of the elderly, again, a lot of older people are more religious and religiously attend church services. Many of them have morbidities, comorbidities that rendered them vulnerable to COVID, and many of them died as a result. The First Amendment's freedom of speech and of the press, again, is designed to ensure the free exercise of ideas, okay? So it's important to keep in mind that democracy is only as good as the people practicing it. And if you are in an environment where people who have political power and influence become intolerant of views that are contrary to their own, you can very frequently, find instances where governmental power is being employed to suppress, acts of dissent, to prevent people from speaking out, to intimidate people. There was recently a situation in Ohio where a sheriff, which again, I believe it was either a city sheriff or a county sheriff, not too far from Springfield, Ohio, where there is a Haitian community that has, their presence has been politicized by the Republican ticket, where they're basically arguing that these folks are not fitting in, that they are a burden on the local community, and they're eating cats and dogs. A local sheriff posted on social media that people should send him the names of people with Harris, Waltz, the Democratic ticket signs in their yard, so they'll know where to send the next wave of immigrants to be placed. Now, this is a reflection of a very old social media meme among people who are hostile to immigration, saying that if you support immigration, why don't you put them up in your home? Well, that's not really a realistic argument, and there is no reason why a person who supports immigration should have the burden of having a family placed in a single family home. Most people's homes are not large enough to accommodate a family of immigrants. It's not a reasonable imposition to say that they should, whether they support immigration or not. Nevertheless, you see people saying that kind of stuff. And you're talking, in this instance, this guy is a law enforcement official making that kind of argument, which to me is outrageous. It raises real questions about that person's character and their capacity to execute their office in a fair and impartial manner. Okay? So it's important to keep in mind, democracy requires freedom of expression and the right to be fully informed. And that means people should have the right to know what alternative arguments are. You have to have freedom of expression even when it leads to disagreement. Democracy is about disagreement and how you manage disagreement. And so the argument of most kind of free speech philosophers and civil libertarians is that the best test of the truth of a proposition is to present it in front of the public in a fair and impartial venue, and have the public decide whether the issue whether one proposal is superior to another one. Now, ultimately, one thing that has happened with regard to civil rights is that the Supreme Court established in the 1950s the idea of strict scrutiny as a standard of review for government attempts to restrict freedom of speech. This is also, strict scrutiny is basically a legal standard saying that if government wants to infringe upon strict speech, on the expression of the speech rights, the speech acts of an individual, those kinds of laws are automatically deemed to be unconstitutional. That reverses the burden of proof. Basically, it creates for the government the burden to show that what they are, that the policy they are proposing is not discriminatory. Now, and I would make the argument, for example, in early on in the Biden administration, 2021, for example, the state of Oklahoma passed a law basically saying that it was illegal for teachers to teach any lessons that made any students feel uncomfortable. Now, I don't know how you teach without challenging people and without, to some extent, making them feel uncomfortable. In my view, first of all, this is just a government infringement into the educative process. We really should be leaving education to educators and not to government. Government needs to step in when we clearly can see that educators are doing something abusive. But that really is not the issue here. Teaching, for example, the Tulsa race riot. How do you teach the Tulsa race riot without or the Tulsa race massacre, if you will, without reflecting on the racism that informed the people that engaged in that massacre? How do you do it? I don't see how you can. And so you're basically trying to intimidate teachers by saying, if you address a controversial subject, like the Tulsa race massacre, you are placing yourself in legal jeopardy. That has a chilling effect on education. And educators are, like doctors, are very much afraid of going to jail and are much more likely to simply be intimidated rather than push back and basically assert their right to freedom of expression, both as citizens of the United States and as educators. Political speech is the most protected form of speech in theory, okay? However, there have been various points where freedom of speech, freedom of political speech has been subject to regulation. In 1791, Congress passed the Alien and Sedition Acts, which effectively, basically barred certain people. The Alien Act basically said, if you are a French immigrant and you are speaking out against the Adams administration, you are subject to deportation. The Sedition Act, now again, sedition is an old-fashioned term that reflects the idea that any criticism of government could be interpreted as an attempt to overthrow the government. And so it is a very broad term that raises very serious questions about whether freedom of expression can truly be protected. Likewise, in 1917, Congress passed the Espionage Act, which basically created an environment where any criticism of government could be viewed as an attempt at espionage against the government. Likewise, the court held in the Schenck decision in that same year, they established what was known as the clear and present danger test for, again, speech acts. And in that decision, the majority opinion writer basically said, the metaphor was, you can't shout fire in a crowded building. And the basic argument was that during wartime, and again, 1917 was, the United States was about to or had entered World War I. The argument was that during wartime, certain kinds of criticism of government were viewed as a threat to national security. And again, what was going on in that period? There were American socialists who were criticizing America's likely intervention in World War I. The socialist argument was that it was a rich man's war, but a poor man's fight. So ultimately, again, broadly speaking, over the course of the 20th century, the Supreme Court has broadened the rights of freedom of speech. The basic viewpoint today is that a speech act can only be criminalized if the speech itself is likely to cause imminent lawless action, okay? Which gave rise, there were a lot of constitutional scholars debating the argument of whether on January 6, 2021, whether Donald Trump actually incited a riot that led to the Capitol invasion. Because he gave a speech on the Ellipse, which was, about a mile or so away from the Capitol, where on the one hand, he did say early in the speech, we have to peacefully protest. But then later in the speech, it clearly, in speech acts that clearly, could be viewed as inciting, he said, you have to fight like hell or you won't have a country anymore. That case has never been brought against Donald Trump. He has basically been indicted for attempting to subvert the 2021 elections through the attempted submission of false electors that would have muddied the waters, led to an inconclusive electoral college result, which would have thrown the election into the House of Representatives, where he would have prevailed. And so, again, when is political speech protected? It is protected when it is very broad. And part of the reason why Trump was never indicted under the incitement, act, inciting a riot. Both federal, state, and local governments all have such incitement, crimes on the books. He was ultimately not indicted because he was President of the United States, and because now he is a former President of the United States, there is a certain amount of deference that is extended to presidents on those grounds. Likewise, it's very important to keep in mind how this relates to campaign activities. In 2010, the Supreme Court issued a decision in Citizens United versus Federal Election Commission, where you actually had a PAC, a political action committee that was supposed to be nonpartisan, that issued a documentary that was profoundly critical of Hillary Clinton. And the Federal Election Commission held that it was a campaign activity, that it was campaign speech. The Supreme Court basically struck down the FEC's rules and basically said that political action committees, 501 C3s and 527s, can engage in basic electioneering activity. And they have subsequently struck down aspects of the federal campaign elections contributions laws, basically saying that people can commit however much money they want to. They're allowed to limit how much that can be contributed to individual campaigns, but they can form their own political action committees and campaign outside the framework of those campaigns. For example, Elon Musk, who owns Tesla and SpaceX and Skylink, and X, which was once Twitter, has said he is going to commit $40 million a month to getting Donald Trump elected president. That is, again, now protected speech under the First Amendment, according to this Supreme Court. Which reflects the idea, and we'll talk more about this in a later presentation, it reflects the idea that the Supreme Court has believed held since the 1970s, the precedent, which is that money is speech, which means that people like Elon Musk have about $40 million more speech than your average American. Fighting words and hate speech. Speech can lose First Amendment protection if it becomes expressive and, again, is designed to incite violence. In the Supreme Court's case of Dennis versus the United States, 1951, the basic view was that there is no substantial public interest served by protecting fighting words. And the old joke in law school is that anything that begins with "yo mama is" considered a fighting word. It is designed to provoke a person to violence. Okay, courts have consistently, however, reversed arrests, and in fact, prosecutors rarely choose to pursue arrests that are based on fighting words alone. However offensive, oftentimes you'll see at protests that protesters will direct deeply offensive speech towards officers, deeply disrespectful speech towards officers. However, if the Speech Act alone is the basis for the arrest, prosecutors very rarely bring them. This actually has become a campaign issue during the 2024 campaign, because during the 2020 Minneapolis unrest following the police-involved killing of George Floyd, there were protests that turned into riots at night. Now, oftentimes, what you had were protests that were organized during the day, and then the people that go to church on Sundays would go home at night when the sun went down. And then you had people both on the far left, Antifa folks, and then people on the far right, the Proud Boys and folks like that, and they'd be brawling in the streets. And so, in many instances, people were arrested because the police started cracking down after the first couple of nights of those riots, including after the first night when a police precinct station got burned to the ground. So police got fired up. They started firing bullets at peaceful protesters, firing rubber bullets. And so many people got arrested in those instances. Kamala Harris and a number of other Democrats made public statements, on the one hand supporting peaceful protests, but at the same time condemning the violence that was occurring in the evenings. Many of the people that were arrested during the day simply for disobeying a police command or directing abusive language at police were subsequently arrested. Kamala Harris gave a statement saying that you should contribute to a fund that was designed to help bail people out who were being arrested in that period. Now, the reality was hardly anyone who was arrested ultimately was charged. And so most of those people didn't need bail. Those few people who did need bail were released on reasonable amounts of bail, like $100 or something like that. So they really didn't need a fund to get them out of jail. Nevertheless, a lot of conservatives have criticized and frankly mischaracterized the actions of Democrats and several other elected officials who were supporting the protests, because again, the protests were about a grotesque instance of police abuse. And so it's unfortunate that this has become a campaign issue, because now, again, policing, finds itself in the spotlight, and you, again, are placing, on the one hand, essential law enforcement personnel who are doing a vital job against people who believe that they should be held accountable when they abuse, members of the community. And this gets back to challenges of over-policing on the one hand, where members of minority communities are harassed and arrested and pulled over continuously and subjected to disproportionately to instances of police violence, against, again, under-policing, where all too often neighborhoods are not patrolled by police, and where crime, drug distribution and prostitution and other forms of criminality are allowed to flourish. Free speech is a very important issue on college campuses, and of course the horrible attacks in October of last year against Israeli citizens by Hamas. They broke out of the barriers, that separated the Gaza Strip from Israel, and they killed over 1,000 Israeli citizens. That has sparked a great deal of protest on college campuses, both because of the heinousness of Hamas's abuse and their taking of hundreds of hostages, but also on Israel's response, which has unfortunately involved large amounts of civilian non-combatant casualties, including many women and children. So the question arises on college campuses: is hate speech protected? And what constitutes hate speech? One of the things that happens at a lot of pro-Palestinian rallies is they do a chant, which is "from the river to the sea, Palestine will be free," or something like it, something to that, effect. Israelis perceive that as a hateful speech act towards Israel. It is basically, in their view, advocating genocide against the Palestinian people. And so part of the challenge is that you've got this conflict that is polarizing key constituencies that happen to exist within the Democratic Party. Jewish Americans, over 80% of Jewish Americans support Democrats. Over 80% of Muslim Americans support Democrats. And so this is an enormous wedge issue. And there are states like Michigan where the Muslim vote is significant enough that it creates a real challenge for the Democrats in terms of how they are managing that conflict. Because, and again, one of the reasons why Joe Biden ultimately withdrew from the race was that he had alienated many of those Muslim Americans, and that was raising real questions about whether he could carry a state like Michigan. Kamala Harris has attempted to, and this is part of the challenge of politics, right? This is the reality, that you have to manage these kinds of conflicts in election years. You're not going to, Kamala Harris can't resolve the problem with the war in Gaza, in part because America's ability to control the Israeli government, which is a very conservative government, that frankly has a lot of members within its, Benjamin Netanyahu, the prime minister of Israel, has many people within his cabinet that are in favor of settler communities, going into the West Bank. And those folks want to go into Gaza too, and they had to be forcibly removed in the early 2000s as part of, again, a political settlement. And in fact, a lot of critics of what Israel are doing are basically arguing that what Israel's government is doing right now amounts to ethnic cleansing. They are making Gaza unlivable for Palestinians, trying to force them out en masse, and then they're going to replace them with Israelis. And similar things are happening on the West Bank, where again, Palestinian communities are being denied access to water, being denied access to religious sites. And as a result, it is making the West Bank increasingly ungovernable. And the Israeli Defense Forces, the IDF, are backing the settlers in those, in those conflicts. And so most people, most international, lawyers believe that what Israel is doing is a violation of international law. And so that is placing the United States in a very uncomfortable position where an important ally is doing something that is, in many people's eyes, morally repugnant. So oftentimes you will have student organizations bring polarizing speakers. There are people out there. Ben Shapiro is a good illustration of a person, on the conservative end of the spectrum, who goes to college campuses and gets paid to deliver speeches that are oftentimes highly polarizing, and oftentimes offensive to liberal student groups. And so they'll attend those speeches and try to shout Shapiro down. Now, I happen to think that that's not the way to approach offensive speech. I think the remedy to offensive speech is corrective speech. You remonstrate with the person and try to get them to understand that what they are saying is problematical somehow. There is always going to be an important constitutional balancing act between freedom of expression and safety. And again, one of the things that's oftentimes happened, I saw it on the University of California at Los Angeles campus. I have a colleague, one of my mentors at the University of South Carolina was a UCLA guy. And there were instances where Palestinian protesters were occupying public spaces on the campus, and they were attempting to bar Jewish students from moving around campus. They were standing in their way, they were blocking their path. That should not be tolerated. Those students should be arrested and subject to suspension or expulsion. That kind of physical confrontation should not be tolerated by any campus administration. At the same time, there have been instances where Palestinian protests have been met with Jewish counter-protests that have been equally confrontational. And oftentimes those kinds of protests are very difficult for campus police to manage. They're simply outnumbered. And so, at times you have to bring in local police to try and manage and de-escalate these kinds of situations. I think it's important to keep in mind both sides have a point, and both sides should be respectful of the other side's perspective and engage rather than seek to suppress those viewpoints. Associate Justice Oliver Wendell Holmes once said, "If there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate." That is the challenge of any democratic nation or community. How do we accommodate? How do we, instill in our citizens how do we train our citizens to be respectful, even when the speech that someone is speaking is hateful in our ears? That is a challenge, and that is, I think, a perpetual challenge for all communities. America side by side, if you look, again, civil liberties in global perspective, and what you will find is, those states that are partly free or not free are ultimately states where you have authoritarian governments who, frankly, do not respect the idea of civil liberties, okay, which is, in my view, an essential element of any democratic community. In fact, Fareed Zakaria, who is an important journalist and scholar, he has for a long time been the managing editor of Time International. He has a program on CNN. He basically coined the term illiberal democracies, basically making the point that many countries like India or Nigeria may be on the pathway to democracy, but it won't be a liberal democracy where, again, you'll have these ideas of individual rights protecting people from governmental infringement. I would make the argument that the idea of illiberal democracy is an oxymoron. You cannot have democracy without civil liberties, because inevitably the government will infringe upon people's civil liberties in order to suppress the dissent of would-be rivals. And if you look at India on this map, it is now judged to be partly free, in part because the party that is led by the current Prime Minister, Narendra Modi, is an Indian nationalist party, and they are not respectful of the rights of Muslim Indians. They are not respectful of the rights of Sikhs. They are not respectful of anyone that is not a member of their political party. And that is creating incredibly horrible politics. Gang rape is endemic in India right now, and I would argue that it is largely a reflection of the fact that Indian culture has not established that sense of respect for the civil liberties, especially of women. Again, student speech, it's very important to keep in mind. It's protected up to a point. On college campuses, it receives more respect and more protection than it does on K through 12 campuses. In the case Tinker versus Des Moines, 1969, basically the court held that students that put black armbands on their arms to protest the Vietnam War, that was in fact protected speech. Since then, the Supreme Court has moved in a more conservative direction and basically argued that schools could curtail free speech rights of citizens as part of the educative process of teaching someone how to be a respectful citizen. So you have to draw a distinction between educational speech and adult speech, right? And there again, there's a case in Alaska where you had, I think it was the Olympic torch procession, and a student who was off campus at the time held out a banner that had said "Bong hits for Jesus." That was a silly, banner. Nevertheless, he was suspended from school. The Supreme Court basically held that was not protected speech, and that the student could in fact be disciplined. So the current state of law regarding student speech is that administrators can regulate on-campus speech. They oftentimes cannot regulate speech in social media. And there was an instance where you had a young woman who was rejected by the high school cheerleading squad. She did like a TikTok or something like that where she was cursing about the politics of behind the local cheerleading squad. She was suspended from school. That suspension was judged to be excessive and overturned by the Supreme Court, basically saying that when she's doing what she was doing off campus on social media was a matter for her parents, not for school regulators. You also have the idea of commercial speech. Advertisements have traditionally been viewed as entirely outside the protection of First Amendment. That is the snake oil effect. You are not allowed to, sell something that you know is harmful to the community. The Federal Trade Commission retains the authority to prohibit false and misleading advertising. City ordinances banning commercial signage have been upheld so long as the bans are not total. That's again about, there are federal laws basically saying that you can only have a certain number of billboards along a highway because that was becoming so cluttered. And it actually became a federal law because Lady Bird Johnson happened to see it and put a bug in Lyndon Johnson's ear, and he basically got that bill passed. Supreme Court also has struck down bans on advertising related to abortions in 1975, basically held that state laws banning advertisements for abortion that violated, again, the First Amendment. Symbolic speech, speech plus, and the rights of assembly and petition. Again, symbolic speech conveys a political message. That is protected speech. Flag burning the American flag, is protected speech. It is offensive, but again, it is part of the idea that we have to protect even the speech that we hate. Speech plus. Therein again, speech that is accompanied by conduct, such as sit-ins, picketing, and demonstrations. That kind of speech is conditionally protected. It is not protected if you are invading someone's private property. However, if you are out in a public street in front of that person's property, you can engage in that kind of activity.
Likewise, freedom of assembly is protected, but the right to assemble on private property is subject to regulation in the interests of public order. Likewise, we oftentimes have people from Westview Baptist Church that come to this campus. They're free to protest. However, they have to go to a place that is designated by school officials as safe. And oftentimes they'll put them in an out-of-the-way place where they can be on campus and can yell at students from afar, but where they can't directly intervene with students, confront students, and engage in offensive speech that offend, in particular, our female students. Freedom of the press, again, in two cases, in Neer versus Minnesota and in New York Times versus United States, the Supreme Court has upheld freedom of the press and basically said that the remedy for speech that is damaging or libel is civil litigation after the production of the printed matter. Can journalists be compelled to divulge their sources? This has been a question that has been raised quite a bit in legal cases. The federal government currently does not have a shield law which enables journalists to protect their sources. In fact, there were a couple of journalists that were jailed, by federal court order because the Obama administration was attempting to identify leakers, administration leakers. And again, that was a Democratic administration that was basically saying, we want to police people who are engaging in what we consider to be illegal speech acts. Nearly 40 states have shield laws, but again, the federal government does not. Libel and slander are generally not protected, but again, it's a very high bar for public officials to be able to establish both libel and slander. Libel is where you're defaming someone in printed word. Slander is where you're using the spoken word. For example, again, Fox News ended up settling a huge libel lawsuit with Dominion Voting Machines, the company, settling a huge out of court settlement, nearly $787 million. The unifying themes of libel and slander are reckless disregard for the truth that damages its victim due to malicious, scandalous, or defamatory nature of the expression. Most libel suits touch on freedom of the press. Again, in New York Times versus Sullivan, a civil rights case that involved a situation where the Southern Christian Leadership Conference had basically run an ad in the New York Times calling for support for the civil rights actions in Birmingham. Thomas Patterson and Louis Sullivan was the chief of police, sued the New York Times and the Southern Christian Leadership Conference in Alabama courts for libel because there were some factual inaccuracies in that advertisement. The Supreme Court held in that 1964 case that mere factual inaccuracies are not enough to justify a libel verdict, that a person had to be acting with reckless disregard for the truth. And again, we're frequently seeing in an increasingly more partisan media that media are coming up and getting sued for libel in a lot of these kinds of situations. So some Supreme Court justices, including Clarence Thomas, have called for lowering the standard. Unsurprisingly, because Clarence Thomas has frequently been subject to critical media attention for his acceptance of large gifts from private sponsors, people like Harlan Crow, who's a very wealthy private citizen, wealthy oil guy, who has lavished gifts upon Clarence Thomas. He has received millions of dollars in travel, and other kinds of gifts. He sent Clarence Thomas's adopted son to private schools. These are things that raise questions about Clarence Thomas's objectivity in hearing cases that may involve interests that relate to Harlan Crow. Samuel Alito has similarly been, had stories run that are critical of his acceptance of these kinds of private gifts. So that's all we have for today. When we come back, we will continue our discussion of civil liberties. I'll see you next time.